It is now my greatest pleasure to introduce the Speaker of the Legislative Assembly, the Honourable Mr. Greg Piper, to welcome you. Thank you, Greg.
Thank you. Lovely to be here, and unaccustomed as I am to standing at this particular spot in this chamber, I shall do my best. Can I start by acknowledging the traditional custodians of the land on which we meet, the Gadigal people of the Eora Nation. I also wish to acknowledge the custodians of lands from all of those areas where people have come tonight and where we are being viewed on the live stream. To elders past and present, I wish to acknowledge them and to pay my respect to those people who emergent Aboriginal leaders. We do this because so much of the impact on our First Nations people since European settlement has come from decisions that came out of this place. Australia's first parliament, the Mother Parliament, and the traditions that started there, and what many would consider a lack of proper consideration for our First Nations people, manifest from this place first. By acknowledging that, I would hope that decisions that go on from here into the future are for the betterment of all, including our First Nations people. Can I welcome you all to Australia's first Parliament on behalf of myself, as I said, Greg Piper, the Speaker of the Legislative Assembly, but also my good friend, the President of the Legislative Council, the Honourable Ben Franklin, who can't be with us here tonight. However, his Chief of Staff has joined us, so thank you for that, Will. There are so many people here who I wish to acknowledge, and I will get through at least some of them, but I'll just say it's a historic occasion on many levels, including that we've got members of Legislative Council here. So it's not usual that we see members of the Legislative Council in this House, but it's wonderful that we can open the Legislative Assembly up to all to come in here and enjoy such an important commemoration of the first woman to enter Parliament in New South Wales, Millicent Preston-Stanley, and I wish to acknowledge members of the Preston-Stanley family who have joined us here tonight. It was wonderful to meet with them in June when we held a commemoration in the Strangers' Dining Room with former members of the Parliament from the Legislative Assembly and the Legislative Council to recognise that momentous occasion. I have to say it was momentous. I can barely imagine how that would have been for the very first woman to enter this extraordinarily privileged and considered to be almost exclusive male domain. But she did it. The member for Eastern Suburbs in 1925, Millicent Preston-Stanley, and it should always be remembered because it was the first step in making fundamental and important changes to the way in which New South Wales has been run. So that was just an amazing event, and I hope that people enjoy this event just as much, if not more, because we're going to see some amazing reenactment. And while I won't be here, I do apologise. I have seen some of it this afternoon, so it was wonderful to be able to do that. As was said, we have this in two parts tonight. So first, we're going to have a keynote speech, and that's from our Honourable Virginia Bell. I just had the absolute pleasure of meeting Virginia earlier. I mean, I've known her for all of 20 minutes and we're besties. No, maybe not, but we are having a contest around the powers of the Supreme Court and the Assembly, but the Assembly right now is prevailing very well, thank you. And it was a wonderful opportunity to get to speak with Virginia for a while. She's going to speak to you, and then you're going to see a wonderful reenactment. So to be able to be part of that, I have to say, is to me, it's an honour, it's a privilege for me to be the Speaker at a time when we are able to commemorate the 100 years since Millicent Preston-Stanley came here. So it's now my great pleasure to introduce our keynote speaker. And while I do know you so well, Virginia, I'm going to read the notes, okay, so I don't get it wrong. The Honourable Virginia Bell AC, SC, served on the High Court of Australia from February 2009 until her retirement in March 2021. At the date of her appointment, she was a judge of the Court of Appeal of the Supreme Court of New South Wales. Prior to this, she served as a judge of the Supreme Court's Common Law Division for 9 years. She was president of the Australasian Institute of Judicial Administration between 2006 and 2008. In 2012, she was made a Companion of the Order of Australia for eminent service to the judiciary and as an advocate for the economically and socially disadvantaged. In 2022, she conducted an inquiry for the Commonwealth into the former Prime Minister's appointment to administer multiple departments of state. That was interesting. Tonight, she will share her expertise on a very important piece of legislation, the Women's Legal Status Act 1918, which gave women the legal right to become solicitors and barristers and to be elected to Parliament, and which, of course, then allowed Millicent Preston-Stanley to be elected in 1925. I wish to thank Justice Bell so much for taking this on, and I know that she will speak so well because she's so passionate about these issues. Thank you, Justice Bell. Thank you.
And now, in what I have to tell you is a terrible display of discourtesy, Mr. Speaker's told me he's got to nick off.
Order.
And subject to disciplinary proceedings at a later time, I'm going to let him. Can I firstly just embrace Mr. Speaker's warm and generous acknowledgement of country and endorse it. And members of the Legislative Council who are here, thank you for attending in this rather extraordinary circumstance, and ladies and gentlemen, and particularly members of the Preston-Stanley family. Let me start by pointing out that the newly federated Commonwealth of Australia led the world in women's rights. In 1902, the Commonwealth Parliament enacted the Commonwealth Franchise Act, which gave women the right to vote and the right to stand for election to the Commonwealth Parliament. Australia was the first country in the world to confer that dual right on women. That same year, Vida Goldstein was the Australian delegate to the International Women's Suffrage Conference in Washington. Such was the novelty of Australia's treatment of women that she was feted as a celebrity throughout her trip to the United States. Before leaving, she was granted an audience with President Theodore Roosevelt in the White House. He told her that Australia's experiment in equality was a great object lesson. Within a few years, Vida Goldstein and her fellow suffragists had come to see the vote, if not a hollow victory, certainly a victory that was very far from securing the equality that they had hoped for. Women's economic dependence, their exclusion from public office, and their subjugation in matters of sexual morality put them well behind the eight ball, whether they had the vote or not. And the laws that perpetuated these inequalities were by and large the laws enacted by the state legislatures. In New South Wales, while women could stand for election to the Commonwealth Parliament, they were ineligible to be returned to either house in this Parliament. The Women's Franchise Act of 1902, passed by this Parliament, gave women the right to vote in in elections for the Legislative Assembly, but Section 4 provided nothing in this Act shall be taken to enable or qualify a woman to be nominated as a candidate at any election or to be elected as a member. It was to take almost a quarter of a century after women got the vote in New South Wales before Millicent Stanley Preston, the first woman, could be elected to this chamber. Section 4 of the Women's Franchise Act couldn't have stated the disqualification of women more clearly. The position as far as the admission of women to practice as barristers was a little more nuanced. Under the Legal Practitioners Act of 1898, a board comprising the judges of the Supreme Court, the Attorney General, and 2 barristers was established to approve what the legislation defined as properly qualified persons for admission to the bar. In 1902, Ada Evans qualified in law with a degree conferred by the University of Sydney. But notwithstanding being properly qualified, she was not admitted to practice because it was considered that a woman was not a person for the purposes of the Legal Practitioners Act. That was so, I might add, not wishing to become overly technical, notwithstanding the fact that under the Act's Interpretation Act of 1897, it was provided words importing the masculine gender shall include the female's gender. Evans was advised that an application to the Supreme Court to compel the board to admit her had no prospect of succeeding. Ada Evans faced a long struggle to secure her ultimate admission to the bar, and it took a considerable toll on her. She had commenced her law studies at Sydney University at a time when the Dean of the law school, Professor Pitt Cobbett, and at that point I'd like you to boo, was out of the jurisdiction on sabbatical leave. He evinced displeasure on his return on finding that the law school had acquired a female law student during his absence. That displeasure didn't lessen with time. In its report of the graduation ceremony at which Ada Evans graduated, the Australasian newspaper said this: Professor Pitt Cobbett, who is a bachelor and not partial to women, could not conceal his disapproval as he introduced the interesting-looking girl to the Chancellor, who smiled pleasantly. The report went on to record that there was not an act in force which would allow a female holding a Bachelor of Laws degree to practice, and that Ms Evans planned to agitate for a new act. The report concluded by noting that at present every judge in Sydney is opposed to the admission. In February 1904, the Women's Progressive Association sent a delegation to Attorney General Bernard Wise, and again perhaps a small expression of displeasure is appropriate. The delegation was there to press for women to be admitted to the legal profession. It was led by Annie Golding, who was a notable champion of women's equality. Bernard Wise was not. He advised that women couldn't be admitted under the law as it stood. Now, Annie Golding was a practised political campaigner. She ensured a very full report of the meeting was reported in the press the following day. Ada Evans read the report and was prompted to write to Wise and press her case personally for reform of the law. Between February 1904 and 1917, Ada Evans wrote to successive Attorney Generals seeking a change in the law. In 1905, the Women's Progressive Association's deputation was received by then Attorney General Charles Wade. Charles Wade's response to their demand showed a degree of political acumen. There was no call, he told the women, for any legislative amendment. This was simply a matter of practice and a question of the rules of the Supreme Court. Annie Golding took him at his word and wrote to the Chief Justice, Sir William Cullen. Sir William responded promptly that the admission of women to the practice of law was most absolutely a matter for the Parliament. Chief Justice Cullen you don't need to boo at. He shouldn't be taken by that response as any suggestion that he was personally hostile to the cause of women. As acting dean of the Sydney Law School, it was William Cullen who had admitted Ada Evans to the study of law. It was Sir William who showed the very considerable discernment to marry Lady Cullen, who was at the time one of the leading members of the women's movement. Sir William's view that legislation was necessary to remove the disqualification for women's admission to the bar was, I have to say, an entirely orthodox and correct statement of the law as it stood. Enid Campbell, the first woman to hold a professorial chair in law at any Australian law school, has explained that the common law set its face against women discharging any functions that were considered to impose on the holder some element of public trust. Prominent amongst the suffragists who supported Ada Evans' struggle for admission to the bar, and a staunch campaigner for equality for women, was Rose Scott. Scott campaigned for what she described as women to be appointed to positions of authority and dignity in the state. Scott was an independently wealthy woman who was, as they say, deliberately single, having famously observed that life's too short to waste it in service of one man. She devoted her life to improving the lot of women, and to her great credit, to improving the lot of women who were less economically and socially well off than she was. She was a great supporter of marginalised women. At the same time, she ran what was the most fashionable salon in Sydney at the time, from her home in Jersey Road, Wallara. The Attorney General Bernard Wise frequented the salon, but the gulf between them remained an unbridgeable one. As Attorney General, Bernard Wise opposed the Crimes Girls Protection Bill, which sought to raise the age of consent for girls from 14. Scott was committed to the measure, having seen the exploitation of girls who were too young, as she put it, to have much, if any, understanding of sexual intercourse or its consequences. Wise, for his part, was concerned with the risk of blackmail by promiscuous, precocious harlots. Among the arguments recorded in Hansard against the bill was the suggestion that by one of the male members of this chamber, that in subtropical Australian conditions, girls ripened into womanhood earlier than in other climes. As Vida Goldstein was to say of another of the bills introduced into this all-male chamber, that would have allowed the indefinite incarceration of a prostitute found to have venereal disease. What difference had women's suffrage achieved if the government of New South Wales felt safe to introduce measures like it? And so matters stood until World War I and the enormous social changes that it brought with it started to make themselves felt. The Women's Progressive Association, under the leadership of Annie Golding, was associated with the Labor Party, and in 1916, at the Labor Party conference, it was persuaded to pass a motion urging the passing of legislation to redress women's legal status. The death of Bernard Wise in 1915 and the retirement of Professor Pitt Cobbett in 1910 had served to remove two very powerful opponents to that measure. On the 18th of August 1916, Attorney General David Hall introduced the Women's Legal Status Bill to the Legislative Assembly. It was not plain sailing thereafter. On its second reading, former Premier Thomas Waddell successfully raised a point of order and the bill was ruled out of order. Attorney General Hall introduced a fresh bill on the 13th of September of that year. On this occasion, Thomas Waddell excelled himself in opposition. He announced that he'd have no objection to the bill if the constituencies were to be divided into two, and women elected their own representatives and men elected theirs. When he settled down, Waddell asked how any woman could have as much knowledge as a man of the mining laws, of land laws, and the many other matters with which parliamentary representatives had to deal. The bill did, I should say, have its supporters, with more than one member pointing to the work that women had done as part of the war effort as giving the lie to the suggestion that they weren't equipped to take their place in Parliament. However, in September 1916, the Labor Party was bitterly divided over the conscription issue, with the result that the government ultimately fell. There was a coalition government. Attorney General Hall was again appointed Attorney General, but in the circumstances that had occurred, the Women's Legal Status Bill had been overwhelmed and it lapsed. A second Women's Legal Status Bill was introduced in October 1918. In speaking for the bill on that occasion, Attorney General Hall graciously acknowledged that he had studied law with a female student whose pass had been better than his own. And he noted that she had occasionally communicated with his department, inquiring when she might be permitted to practice law for the profession for which she had qualified 17 or 18 years earlier. The bill encountered an obstacle in the Legislative Council because, as it was drafted, it would have removed the disqualification on women sitting in both chambers. Any measure to alter the constitution of the Legislative Council had to originate in that chamber. The bill as drafted was found to be an invasion of the privileges of the council. I don't want council members booed at this point. And so the bill was returned to the Legislative Assembly. There it was amended to confine its operation to the removal of the election of women to this chamber. And it received a warmer reception. Albeit Dr. Nash, who was one of the few members of the Legislative Assembly who had served at the time when the Women's Legal Franchise Act had been passed, announced that he looked on the measure as a joke. Nonetheless, it was passed and it received the royal assent on the 21st of December 1918. It's outside in the hall, the original copy, which was secured for this important centenary year in terms of a woman's membership of the chamber. It provided that a person shall not by reason of sex be deemed to be under any disability or subject to any disqualification from being elected to act as a member of the Legislative Assembly or as an elected member of a local council, or to be appointed a judge or a magistrate, or to be admitted to practice as a solicitor or barrister. An undercurrent in the Hansard debates on the bill was the view that its enactment wasn't going to disrupt the apple cart. The electorate, it was felt, was not going to return women members, and the legal profession wasn't going to be overwhelmed by them either. Unpalatable as that view may have been, it did have an essential truth to it. The social and economic pressures which largely kept women in the home were not about to just suddenly give way to the change in their status at law. Few women stood for Parliament and few were returned. At the Commonwealth level, the intrepid Vida Goldstein made 3 unsuccessful bids for election to the Commonwealth Parliament. And as you know, now if I was still in office, that'd be 3 days' cells. To return to my subject after that interruption, the first woman, of course, was Millicent Preston-Stanley, who we're honouring tonight. She was one of the new generation of feminists. In 1919, she assumed the presidency of the Feminist Club. She was a powerful advocate for women, particularly on issues of infant and maternal mortality and the guardianship of children. She was a generation younger than Rose Scott and those pioneers of the suffragette movement. She was born in 1883. Her background was distinctly less privileged than Scott's. Her activism on behalf of women and children is as likely to have been inspired by her lived experience in her early years as much as by lofty ideals. Her father, a grocer, was an alcoholic who deserted her mother when Millicent was a young child. In November of 1894, when Millicent was 11, her mother petitioned for divorce on the grounds of desertion, and thereafter her mother raised Millicent and her 2 siblings alone. The shame of divorce at the time no doubt explains why, following her election to Parliament, in an otherwise very flattering press article, Millicent gave an account that her father had died when she was a young child. In fact, we know that he was very much alive when she was 23, because in 1906 there's a report of him appearing before a court in Kalgoorlie over a minor charge when he spoke of its commission at a time when he was drunk. That same year, 1906, Millicent became a council member of the New South Wales Women's Liberal League under the presidency of Hilma Molyneux Parkes. She was a contemporary of Rose Scott's, one of the original suffragists, and very much Millicent's mentor. The object of the League was to improve the position of women in society. You might be aware that today there's a Hilma's network aimed in her honour that continues to have the desire to increase the representation of women in the federal, state and territory parliaments. Millicent wasn't only active in the Women's Liberal League and the Feminist Club. Unsurprisingly, given the history, she was very much involved in the temperance movement at the time. And notably, before women were even eligible to stand for office, she is reported as early as 1916 to have been as regular a sight in the ladies' gallery of this chamber, as was the Speaker. In 1919, she was in Cairns, where she addressed a country party meeting and is reported to have created pandemonium with the fervour of her attacks on the Wobblies, the industrial workers of the world. A theme throughout her public life was her abiding fear of communism and socialism. When she gained pre-selection for Parliament, it was for the Nationalist Party, which was a direct predecessor to today's Liberal Party. All of this just makes it curious to learn that when in her early 50s she found time to get married, it was to the former Labor Premier of South Australia, Crawford Vaughan. By all accounts, a happy union. They remained married till his death. But I'm getting ahead of myself. I should note that notwithstanding all her activism, by the early 1920s, Millicent was established here in Sydney in a real estate business. In 1921, taking advantage of women's newly acquired status, she became a Justice of the Peace. From 1923 until the year following her election to Parliament, she was president of the Women Justices Association of New South Wales, a rather small group, I imagine. She failed to gain pre-selection in 1922 when she was listed fifth on the Coalition's ticket. But in May 1925, she was returned as a member of the Nationalist Party to the Legislative Assembly in the seat of the eastern suburbs. Her maiden speech was delivered in this chamber on the 26th of August 100 years ago. Her principal efforts in the House were directed to the equal guardianship of children, and partly those efforts were prompted by the case of Emily Pellini. Pellini was an actress who'd enjoyed success, considerable success, in London and New York. She had been contracted by J&N Tate, a theatrical entrepreneur, to take up an engagement in Sydney. On the ship coming out, she met Lieutenant Harold Ellis, who was returning home from service with the Royal Field Army. And in 1918, they married. Pellini made over to him her savings to enable the purchase of a property at Hartley Vale. In October 1921, their daughter Patricia was born. By March of the following year, Ellis, who had mortgaged the Hartley Vale property, had managed to lose everything. They separated, and Pellini returned to the stage to support herself and her daughter. She arranged for Ellis's mother to look after Patricia while she was performing in a J.C. Williamson's production. On the completion of her engagement, she wanted to return to England, where her sister could help her with the care of Patricia. Ellis refused to consent to Patricia leaving the family. Pellini applied for and was refused custody. The Chief Judge in Equity, Justice Harvey, found that there was no suspicion of any misconduct on Pellini's part. As for Mr. Ellis, neutrally, Justice Harvey observed that he had shown decided weakness of character. Nonetheless, His Honour explained the law in New South Wales didn't put the wife's rights to custody as high as in England. Since 1886 in England, in a custody case, the court was required to give some consideration to the wishes of the mother as well as the father. Not so here. Under the guardianship law in New South Wales, the father of a legitimate child had custody and guardianship of the child, and that was that. Ellis and Ellis was decided before Preston-Stanley entered the New South Wales Parliament, but she was galvanised by it. She took up a petition and obtained a very large number of names and presented it to the then New South Wales Minister for Justice, Thomas Leigh, a man later, I just in passingly observe, was convicted before the Old Bailey as the chalk pit murderer, but that's another story. With a tenderness that's not always exhibited by parliamentarians, Leigh declined to take any action on the petition, saying it was not the practice in English-speaking countries to bring in legislation specially for the purpose of upsetting a decision of a judge. So Preston-Stanley gets herself elected, and on the 2nd of November 1926, as a member of this Assembly, she moved to bring in a bill to amend the law relating to the guardianship and custody of infants. The object of the bill being to require the court to take into account the wishes of the mother as well as the father in matters of access and custody. Edward McTiernan, then Attorney-General for New South Wales, later to be the longest-serving justice on the High Court, was strict in ensuring observance of the time limits allocated to private members' business. In short, based on the rulings that Sir Edward made, there was no time for her bill to be read on that day when it was introduced, or on any day thereafter. Just again, as a slight aside, I'll mention that in my first or second year of law studies, Sir Edward was still on the High Court bench. There was a notice affixed to the law school notice board advising that Sir Edward was looking to engage an associate and that female students need not apply. But to return to my theme, Preston-Stanley's eastern suburbs seat was abolished in 1927. In the fresh elections, she ran as an endorsed candidate for the Nationalist Party, but H.V. Jakes, a man, stood as a sort of independent nationalist. He won the seat and then received the party's support. Undeterred by her electoral loss and the failure of her bill, Preston-Stanley wrote the play Whose Child? This dramatically interwove Emily Pollini's case with the saga of Preston-Stanley's unsuccessful private members' bill. She hired the Criterion Theatre, then on the corner of Park and Elizabeth streets, since demolished, and she engaged a professional director and actors. She cast herself in the role of the female parliamentarian, and she took out advertisements reading or promoting this tense, throbbing drama of real live interest to women. Whose Child opened in November 1932. The Prime Minister of Australia, the Premier of New South Wales, the Lord Mayor and other dignitaries were all in attendance at her invitation on the opening night, as was Lewis Martin, the Minister for Justice. At the curtain call, Preston-Stanley, with a true feel for the dramatic, announced that during the interval, Mr. Martin had sent a note backstage to say that he would give instructions for a bill to be prepared to provide for mothers' rights so eloquently depicted in your play. True to his word, Martin introduced a bill in September 1933 to amend the statute governing the guardianship of infants. The amendments came into force on the 1st of November 1934, and as the Minister put it, this was the concluding stage of a long struggle waged by women's organisations to put both parents on the same footing in relation to child custody. In 1939, New South Wales barrister Nerida Cohen described the impact of the Women's Legal Status Act in a paper published for the Silver Jubilee of the Feminist Club. She bemoaned that 20 years had passed and yet few women were establishing themselves in professional and public life. And while one sympathises with her frustration, it is fair to observe that before the changes in society in the 60s and early 70s, among which effective birth control must surely rank high, the forces limiting the practical achievement of equality for women in the public sphere were powerful. It wasn't until 1939 that the second woman, Mary Clerk, was elected to this chamber, and over the 50 years after Stanley Preston's election, only 3 women were elected to the Legislative Assembly. She was a truly remarkable, staunch trailblazer, and it's very fitting that her pioneering advocacy for women should be acknowledged tonight on the centenary of women being elected to this august chambers. Thank you.
Thank you so much, Justice Bell. That is an absolutely brilliant overview of the trials and tribulations of Millicent Preston-Stanley in this chamber, but of the women that came before her. Let's please give her another round of applause. We will begin, and I will just give a tiny little bit of context. As Justice Bell said, the Guardianship of Infants Bill was actually spoken about by Millicent in this chamber in a year's time, but her first speech was in about 13 days' time. We're not doing that speech. We're going to be looking at the Guardianship of Infants Bill. But I must warn you, we have taken a fair bit of dramatic licence. So I expect you to find every single anachronism in the chamber, but please don't call it out. Just quietly giggle to yourself when you see things that wouldn't possibly have been around in 1925. For example, the mace, we didn't have one. It was gifted to the Parliament in 1974, and our Speaker and our Clerk didn't actually wear wigs, but we wanted some colour and some drama, so we've got them wearing wigs. The other thing is that, of course, when a member speaks at the table, the Hansard reporters only record what is said at the table, and if somebody interjects, only if the member acknowledges that interjection is it put into the Hansard. So we had to use newspaper articles and imagination to kind of come up with what the members might have been saying, because, of course, Millicent Preston-Stanley was not so silly as to have recorded some of what the men were saying. She didn't want those words to be there for posterity. Of course, she wanted her speech to be there. So keep that in mind as you listen to our gentlemen calling out. And we also need to be aware that there would not have been people, members of the public, sitting where you are. That is just reserved for members of Parliament, normally on a sitting day, and that not all the MPs who were elected to this chamber were in the chamber on that day. For example, Premier Jack Lang had just been elected as well, but he wasn't here. He would have been conducting parliamentary business elsewhere. Oh, good evening, Miss Preston-Stanley. I'll be out of your way in just a moment.
Take your time, dear. It's wonderful to see so many people here interested in the workings of our Parliament.
It is, isn't it? Thank you. In a moment, you'll hear the bells ring, which will call all the members to the chamber. But now, without further ado, let us begin. We hope you enjoy this step back in time.
Tonight I will speak in Parliament about a very important matter. As I do so, I am deeply aware that I stand on the shoulders of all those women who came before me. Not in the Parliament. This is a first, a long-awaited first, but in all the previous wins that have got us here. I acknowledge the women who have fought for decades for women's suffrage, finally winning it for us all at both state and Commonwealth levels. And equally importantly, I acknowledge those who fought to pass the Women's Legal Status Act, which allowed women to practice law and allowed me to stand here for Parliament. It has taken such a long time, but here we are. And as I look into the future, I see so many more women gracing not just these sacred benches, but those of all the courts in our nation, the Supreme Court and the High Court. Intelligent, inspiring women, such as the Honourable Virginia Bell. Thank you. It will be a great future, but for now we work towards reform in child welfare, women's health and housing, pensions for all widows, and of course, an act to give mother and father equal rights in custody, the Guardianship of Infants Bill, the motion that I have campaigned for and will speak to in the House tonight. To quote William Shakespeare, "Once more unto the breach, dear friends, once more."
Honourable members, the Speaker.
Almighty God, we humbly beseech thee to vouchsafe thy special blessing upon this Parliament, and that thou wouldst be pleased to direct and prosper the work of thy servants to the advancement of thy glory and to the true welfare of the people of New South Wales. Amen. The clerk will read the order of the day.
Notice of motion, Guardianship of Infants Bill.
Mr. Speaker.
I call on the member for Eastern Suburbs. Order.
Mr. Speaker, I move that leave be given to bring in a bill to amend the law relating to the guardianship, maintenance and custody of infants, to remove certain disabilities of married women with respect to the guardianship of their infant children, to amend the Testator's Family Maintenance and Guardianship of Infants Act 1916 and the Infants Custody and Settlement Act 1899.
Order.
In asking to leave to introduce the bill, I speak in the name of 20,000 women, representing every section of the community. I would like the House to understand that this is no mere figure of speech, because no fewer than 20,000 women signed this petition 2 years ago, which was presented to the Minister for Justice, Mr. Lay.
Listen to the women.
We're trying to.
All right, order.
In that petition, the signatories prayed that the law should be amended to provide that in all proceedings for the custody of infants, where the mother was of unimpeachable moral character, she should be regarded as the natural guardian of her child up to the age of 5 years. And that in making an order for the custody of any child, the court should not have regard to the fact that he or she contemplated leaving the jurisdiction of the court for the purpose of earning his or her living.
You can't have your cake and eat it too.
I would remind the House of the great injustice that was done to women in the case of Ellis and Ellis. This case affronted the sense of right and justice in the minds of thousands of women throughout this state, and led to the petition which I have referred to being presented to the Minister. Mr. Lay was exceedingly sympathetic, but as has often happened in the past, nothing was done.
Point of order, Mr. Speaker.
I call on the member for Balmain.
A minister can't interfere with the ruling of the courts.
No point of order. The member will resume his seat.
Very loose in the top button.
All right, order.
Point of order, Mr. Speaker.
I call on the member for Western Suburbs.
Mr. Speaker, when the member for Eastern Suburbs says that nothing was done, that is an imputation of the minister's integrity.
Point of order. The member will resume his seat.
I ask that rather than suggest offence should be taken, the honourable member should commit to protecting the children of this state. After all, he is married with children and knows something of the difficulties family life entails. But the heavens won't fall because a woman's skirt rustles on these sacred benches.
All right, order. Members will come to order. This is no such notion of motion, not feeding time at Taronga Zoo. Please proceed, Miss Stanley.
Thank you, Mr. Speaker. It is a disgrace to the state of New South Wales that a law should remain on our statute book which permits such grave injustice being done to a married mother of the highest possible reputation. In this case, the custody of a child, 2.5 years, and a girl child at that, was refused a woman even though the judge said that there was not a breath of suspicion against her character, either as wife or a mother.
That is the law.
Order. Members will cease interjecting.
Might I remind this House that we in New South Wales are exactly 85 years behind Great Britain in the matter of legislation to ensure married mothers equal guardianship of their children.
We're in Australia, love.
The British Act of 1839, known as the Telford Act, provided that the mother should be regarded as the natural guardian of her child up to the age of 7 years. This state of affairs has existed in Great Britain for 85 years, and we are exceedingly backwards.
We're not a colony anymore.
We are not. We are better than the mother country.
The ashes.
The ashes, you ask? We're not worried about the ashes. That's the first test they've won since the war.
Order. The members will cease interjecting.
This is a question of interest to every married mother in this state, and it is to consider the justice and equity of their position that I have had on business paper for 12 months, this motion, which I have only been able to reach this morning.
That's terrible tactics. This government does not support women and children. It does.
The government has no shame. You lot have no shame. We're the government. The people voted for us.
That's right.
Members will come to order.
It is extraordinary that every provision in the English Act of 1886 should have been embodied in our own law, except that provision in Section 5, which requires that the wishes of the mother as well as the father be regarded by the court. What we are now asking for is that the portion of the British Act which was left out of our own law be now embodied in it.
Mr. Speaker.
I call the member for Balmain.
When dealing with these questions, the courts every day have regard to the wishes of the mother as well as to the wishes of the father.
The member will resume his seat.
I I do not know how so distinguished an advocate as the honourable member can make such a statement.
Well, I say it's a fact.
It is not a fact.
Order!
Is not your real objection not to the law, but to the application of the law in one case?
No. I'm objecting to the law and not to the application of the law by Mr. Justice Harvey. In fact, I shall refer to Mr. Justice Harvey's decision on that case.
Due consideration has always been given to the rights of the mother as well as the father.
Order! Members will stop using unparliamentary language.
Look, there's no use my saying one thing and the honourable member saying another. We can allow Mr. Justice Harvey to speak for himself.
Let's hear.
He says, the law in this state has not put the wife's right to the custody of the children so high as the law in England has. In England, her mere wishes have to be taken into consideration. In this court, it is necessary to find such a neglect by the husband of his duties as justifies the wife in separating herself from him, or that the welfare of the child requires that it should be placed in the wife's custody. In other words, the law in New South Wales does not require the court to have regard to the wishes of the mother as well as those of the father. This is the great, the vital, the fundamental and the essential difference between British law on this matter and the law of this state. I am sorry to cross words with such a distinguished gentleman as Mr. Everett, but that is the position.
Well, I'm quite satisfied, Mr. Speaker. I did not know of that passage in the judge's decision. I accept what you say.
Oh, my Lord, if you read the report, it would have shown that the judge was sorry for the mother. Sorry. Yes. Can't you read?
Members will come to order. Order! Members will come to order.
I should imagine that any judge in any court of law anywhere in the world would be sorry to have to give such a decision. But unfortunately, the judge here has laid it down very clearly that he had no power, as the law now stands, to give the custody of the infant with whom he was dealing to the mother. A statute which permits such a judgment in a civilised community is entirely out of accord with the 20th century ideals of justice, equality and democracy.
I am so tired of this. What about the father that has done nothing wrong? When do we hear about that?
All our laws are more or less modelled on British laws. In Britain, for 85 years, the rights of the married mothers have been considered.
85 years!
But when I say they have not during that time been considered, nor are they today being considered in this state, I shall have said enough to justify my asking this House to give me leave to introduce the bill.
Not necessary. The law already deals with this in normal cases.
No doubt some honourable members will say that in normal cases, in normal homes and circumstances, there is equality of guardianship. But we are not dealing with normal cases. We are considering cases where there is shipwreck in the home, and where, for any number of reasons, the parties have decided to separate.
I'd be separated if I was married.
Order! The member for Bathurst is on a call. The member for Newcastle is on a call.
You can be as childish as you like. It only strengthens my argument that in such cases we say that if a woman is of unimpeachable character, she should be regarded as the natural guardian of her child. Another thing that we are asking for is where the mother has to leave the jurisdiction of the court for the purpose of earning her living,
You are not married and you are not a mother.
Nothing to do with it. Members will cease interjecting.
Mr. Speaker, the court shall not have the right to say that the mother to whom nature has given an unalienable right and title to the child, because you have to earn your living in Africa, London, or Timbuktu, we shall take your child from you and refuse you custody of your infant baby.
I call on the member for Western Suburbs.
Suppose, for the sake of argument, the wife didn't care to be domiciled in the state if given the opportunity. How would you deal with that case?
The member will resume his seat.
I think the honourable member is not speaking to the point. His remark is irrelevant.
Rubbish. Very good point. Excellent point.
The abnormality might be on the husband's part.
Sit down.
Abnormality.
Who's abnormal? Look around. You're the only one of your type in this chamber.
Order! The House will come to order. Members will be ejected if they do not come to order.
Mr. Speaker.
I call on the member for Balmain.
I have a question for the honourable member. Will the bill be retrospective to cover the case that has been referred to?
When will it stop? 1788?
I am not proposing that it shall be retrospective, but Mrs. Ellis may make application under it for the custody of her infant. However, I shall not pursue the matter further because I want the opinion of the honourable members upon it. It is an extraordinary thing that in a democratic country we should have to plead like this for a mother. If there is to be any differentiation in the status of parents towards their children, then let the inferior status be given to the father. Because children are, in a peculiar sense, the children of their mothers.
Deny fathers their rights.
I would be the last in the world to deny fathers their rights.
You just did.
I would be the last to suggest that a child should be placed under the care of a mother who was not fit to care for it.
Mr. Speaker.
I call on the member for Balmain.
I'm not prepared to oppose the motion that leave be given to introduce the bill. I'm very anxious to see the contents of the measure which the honourable member has prepared, and I will not take up any further the time devoted to private members' business.
What a waste of time.
Mr. Speaker, I bring up the bill.
The question is the motion of the member to bring in this bill. All those in favour say aye. Aye. All those against say no. I think the ayes have it. The ayes have it.
Guardianship of Infants Bill. A bill to amend the law relating to the guardianship, maintenance and custody of infants.
I order that the bill be printed and read for a second time when the House agrees to schedule it. I move that the House do now adjourn.
Thank you. That was rather amusing and wonderfully apt after Justice Bell's talk. Let's give them another round of applause. Thank you, everybody. I'd like to now call upon Ms. Carly Maxwell, who is our acting clerk of the Legislative Assembly, to officially thank our wonderful speaker and our performers. Thank you.
Thank you so much, Daniela, and thank you so much for drafting such a wonderful play that really brought Millicent Preston-Stanley to life for us all. It was fabulous. And thank you to everyone in the audience for being with us tonight for this rather extraordinary event. It was been so fascinating to hear about the Women's Legal Status Act and see the results of that very important legislation played out for us here in the chamber. On behalf of the Parliament, I'd like to give an enormous thank you to Virginia for taking the time to be with us tonight to talk to us all about all these complex manoeuvrings that make up the history of the Legal Status Act. I'm sure we can all agree that the persistence and resilience of women who advocated for their right to stand for Parliament and practice law inspires us all still, over a century later. Please join me in a round of applause for the Honourable Virginia Bell, herself an extraordinary. Now to the stars of the show, many of whom are quite familiar to me. So a lot of the actors you see that were part of the performance tonight are members of the parliamentary community. They're staff here and they've watched way too many proceedings because they did it way too well. I'm kind of disappointed to say, actually. But I'm sure you'll agree with me that we have just witnessed a wonderful reenactment. And Lucy, thank you so much for your terrific performance of Millicent. As a playwright, as we heard, as well as an MP, I think she would have loved to see herself remembered in this chamber 100 years later. Please. Thank you for coming, everyone, and I'll hand you back to Daniela. Thanks.
Thank you so much, Carly, and thank you again, Justice Bell, and thank you to this wonderful, wonderful cast. It's been a terrific evening. Yes. But all great things must end. But luckily, we continue to have fantastic members of Parliament here, and we continue to have fantastic citizens who not only vote for the members, but come along to these programs and make them really worth doing. So give yourselves a round of applause, please.